let's get going. Dan, I know you're going to answer this burning question. Is it legal for employers to require their employees to get the COVID-19 vaccine?
Very good. Thank you, Tracy, and I appreciate the introduction and the opportunity to present this morning to join you and Juanita and hopefully convey some good information to the attendees about this very important topic. And when we're talking about issues regarding COVID-19, of course, even though it's narrow in its scope in some respects, it's also very broad. And we've sort of focused initially on the question you just asked, but as we go through, Juanita and I will attempt to answer your questions on other COVID-related questions because it does impact employers in just so many ways, as you've all experienced during 2020, and as we know, is continuing into 2021. So as we talk about this topic, though, we'll kind of give a couple disclaimers first that we are not intending to provide specific legal advice, and we're giving this information, for general informational purposes primarily, and really only. But along the way, we will try our best to give you the most specific answers we can to your questions, because this subject matter truly is evolving, and the entire business community has to work to stay informed about changes that are happening on the both California and federal levels from the various agencies. As you'll hear about today, this presentation and the timing of it is particularly timely because just yesterday, some new information was published by the Equal Employment Opportunity Commission that relates directly to the topic we'll talk about here today. So all employers need to continue to stay on top of these issues. So we as presenters are not ultimately advising anyone here as to what to do with respect to vaccinations, to require or not to require them, but hopefully the information that we are providing you will be educational and help you with your independent professional judgment as you make those decisions going forward. So the big question, as Tracy just put to us, is whether or not the employer, an employer can require employees to receive the COVID-19 vaccine. So the answer to start with is yes, but a qualified yes, because there are a lot of arms and legs to this complicated issue. And so in terms of, why is the answer a qualified yes? I have this multiple choice selection here. A, because attorneys are not capable of providing anything but qualified answers. Possibly true. The answer may depend in part on the employer's industry. Risks exist even if mandated vaccinations are legal. Employees can establish reasons to avoid receiving the vaccine and all of the above. So probably the answer is all of the above if I give you partial credit for A, but I'm not conceding that point at this point. All right, so let's start with, in terms of the legal issues that arise and sort of setting the table for the topic, and that is that when we're talking about medical issues and disability-related issues, medical examinations, whether you can ask employees questions about medical issues. A lot of that is based on what the law allows pursuant to the Americans with Disabilities Act that applies to companies with 15 or more employees, or the California Fair Employment and Housing Act, FEHA, that applies to employers with 5 or more employees. And essentially the two statutes work together and are very similar in their instruction to companies in that they both prohibit employers from making employee disability related inquiries or in conducting medical examinations unless those inquiries or examinations are job related and consistent with business necessity. And in order for such an inquiry or examination of an employee to be job-related or consistent with business necessity, the employer has to have a reasonable belief based on objective evidence that an employee's ability to perform the essential job functions will be impaired by a medical condition, or that the employee will pose a direct threat to a medical condition. And so a lot of the discussion around the employer's rights to have medical examinations, whether the vaccination even is a medical examination, what the employer's rights on this topic are, really focus on whether or not the circumstances with this pandemic create a direct threat due to a medical condition. Is the employer, are employers potentially facing a direct threat as a result of the spread of the coronavirus? And when the employer is making that decision about whether they have a reasonable belief, it has to be based on objective evidence obtained, or reasonably available to the employer prior to making the disability-related inquiry or requiring a medical examination. So when we take that basic premise and we look at, well, what is a direct threat? How do we define that under the law, under the Americans with Disabilities Act and under FEHA? The courts have told us and the regulations have told us that a direct threat is a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by reasonable accommodation. And if an individual with a disability poses a direct threat despite reasonable accommodation, then he or she is not protected by the discrimination provisions of the ADA. So the employer then must undergo some type of assessment as to whether or not an employee poses a direct threat in the workplace. So we take all of that information, all that legalese, and we apply it then to this issue of COVID-19 and specifically that coronavirus impacting us as businesses and business owners and how it affects co-employees, et cetera, and what risks does it potentially create as we operate our businesses and trying to both stay in business, but to operate in a way that we don't have the coronavirus spreading through our particular workplace. So with that said, then do we have evidence or support that exposure to COVID-19 poses a direct threat in the workplace as defined by the law? And we have answers to some extent from the Equal Employment Opportunity Commission. The EEOC is a federal agency. It's the US EEOC that has jurisdiction over deciding matters of discrimination, essentially. They enforce the Americans with Disabilities Act, they enforce Title VII, that creates other protections against discrimination. And in publications that they've created during the last year, specific to the pandemic, they have published, for example, what I have this excerpt here from the Pandemic Preparedness in the Workplace and the Americans with Disabilities Act. This language that you see here was last updated in March. We'll talk in a few minutes about whether, the fact that there is even more current information that was just recently published. But in this publication from the EEOC, they have directly come out and said that based on guidance of the CDC and public health authorities as of when this was published in March and continuing through today, the COVID-19 pandemic meets the direct threat standard. So they have expressly said that this entire pandemic that all of us are enduring does meet that direct threat standard. And so we have that specific opinion from the EEOC that provides employers then a basis for responding to the pandemic in the workplace, understanding that they've already met that threshold, that legal threshold, that the pandemic does potentially create the direct threat to employers. And so the EEOC is saying that the facts that we have found manifestly support a finding that a significant risk of substantial harm would be posed by having someone with COVID-19 or symptoms of it present in the workplace at the current time. So we have direct support then through the EEOC that we've met that direct threat standard. And the EEOC has also published additional information through its Q&A that is available on its website, talking about pandemics in general. As you see here, I have a few sections highlighted. The first one I have highlighted is to point out that this Q&A that we have up here on the screen right now is not talking about COVID-19 specifically. It's talking about the influenza pandemic, but still, this was published in connection with the current pandemic, and the EEOC posed the question, may an employer covered by the ADA and Title VII of the Civil Rights Act compel all of its employees to take the influenza vaccine regardless of their medical condition or religious beliefs during a pandemic? And you see the beginning of the answer says no, which at first blush might cause you to think, well, so is the EEOC saying that we cannot compel employees to take a vaccine? That's not really what this is saying. With many things that we look at in terms of the Q&A, we have to focus on, the kind of the call of the question. What are they specifically asking here? And you see in the underlined parts of the question that I have there that it's important to study the question and the answer in terms of what it is they're specifically asking. So here, the way they phrase the question, they say, may an employer, covered by the ADA, et cetera, compel all of its employees to take the influenza vaccine, regardless of their medical condition or religious beliefs? So of course the answer is going to be no, because there are rights that employees have in terms of being compelled to take any vaccine that they can raise to avoid having to actually receive the vaccine. So if an employer imposes a mandatory vaccine requirement as to the flu, the EEOC is saying employees can object to that mandatory vaccine requirement by raising concerns, for example, that they have a disability that would preclude them or should prevent them from receiving the vaccine, or they have a sincerely held religious belief or practice that also would preclude them from being forced to have the vaccine, the influenza vaccine. So in essence, the EEOC through this Q&A is implicitly saying that if the circumstances exist where there is a direct threat, that in fact an employer can mandate the influenza vaccine subject to these exemptions that an employee may raise to avoid actually personally having the vaccine themselves. And then you see the last section that I highlighted there, that at the time that this Q&A was published by the EEOC many months ago, there was no vaccine available for COVID-19, but obviously that's beginning to change as we see the vaccine starting to roll out across the world. So taking that information then, we move to what's happened in the past few days. So the EEOC published some new guidance just effective yesterday regarding this very timely topic. So one thing I'll note here, this is just goes to show what a strong and great, Chamber of Commerce we have here. The Greater Bakersfield Chamber of Commerce, set up this program several weeks ago using apparently their psychic or intuitive knowledge that just the day before the presentation, we were going to get a whole new set of guidelines that specifically go to this particular question. So that's how good the Greater Bakersfield Chamber of Commerce is. And so talking about that then, in terms of how it impacts our specific topic today, the EEOC published, again, effective just yesterday, a document that is entitled, What You Should Know About COVID-19 and the ADA, the Rehabilitation Act, and other EEO laws. And it's a technical assistance Q&A. You see the link there on the page as well, if you want to go to it as well. I'm going to be talking about some of the excerpts from it that directly address this question of, can an employer mandate that employees receive the COVID-19 vaccine? So some of the Q&A that it was published yesterday, start with, some separate issues having to do with, as you see here, as they phrase the question, for any COVID-19 vaccine that has been approved or authorized by the FDA, is the administration of a COVID-19 vaccine to an employee by an employer or by a third party whom the employer contracts to administer a vaccine, a medical examination for purposes of the ADA. So this new publication starts with the answer no, that this vaccine for COVID-19 is not in and of itself a medical examination. So the administration of that vaccine, they're concluding, is not a medical examination, which is an interesting conclusion, but helpful to employers, because if it's not a medical examination, it takes it out of a lot of the other protections that would otherwise be imposed by the Americans with Disabilities Act or arguably the Fair Employment and Housing Act. By comparison, just as a note of interest, the COVID-19 viral testing that has been in place now for many months, and even the procedure of taking employees' temperatures were concluded by the EEOC, in the last 9 months to be medical examinations. So those were medical examinations, but actually getting a vaccination is not a medical examination. So I'm not going to go into the analysis of how that apparent contradiction could be true. We'll take the good news as we get it, which is that the EEOC is concluding that the vaccination itself is not a medical examination. And they define a medical examination as a procedure or test usually given by a healthcare professional or in a medical setting that seeks information about an individual's physical or mental impairment. And so they've concluded that because the administration of the vaccine itself does not require seeking information about an individual's impairments or current health status, it doesn't meet the definition of a medical examination. So that makes sense, even though it's perhaps a hyper-technical explanation or analysis, we'll again take the good news as we receive it. But the EOC says that even though the administration of the vaccination itself is not a medical examination, there are things that come along with oftentimes administering a vaccination that could trigger other rights and obligations under the Americans with Disabilities Act. So to the extent that the pre-screening vaccination questions that may be asked prior to the actual administration of the vaccine, those type of pre-screening vaccination questions are likely to be disability-related inquiries, because who's ever administering the vaccine will necessarily be asking questions about the person's health status and such. And so because those inquiries are likely to elicit information about a disability, then to actually ask those questions in the pre-screening process, the employer would have to show that it's necessary to do so and it's job-related, consistent with business necessity. So the EOC, in a sense, is saying two things. One, the vaccination itself is not a medical examination, but employers, you still need to be very careful about how you go about rolling out this potential mandatory vaccine, because it could trigger these other obligations that you want to be careful about in terms of potentially asking questions that are protected under the ADA. In addition, this new guidance asked the question, according to the CDC, healthcare providers should ask certain questions before administering a vaccine to ensure there is no medical reason that would prevent the person from receiving the vaccination. If the employer requires an employee to receive the vaccination from the employer or a third party with whom the employer contracts to administer a vaccine and ask these screening questions, are these questions subject to the ADA standards for disability-related inquiries? So before I get to the answer, a couple things that kind of jump out at us in terms of how that question is phrased. Because the second part of the question refers to if the employer requires, you see there that the EOC is already implicitly saying that we think that mandatory vaccinations are okay. Otherwise, they wouldn't have phrased the question that way. And we'll get into that more in just a moment. So we see through these new guidelines published by the EOC effective yesterday that the EOC is essentially saying that we think mandatory vaccinations are okay. There's caveats that come with it, but from the starting premise of answering the big question, can an employer require employees to be vaccinated? The EOC is essentially telling us yes. And so with respect to this question specifically and the process of administering the vaccination and asking pre-screening questions, the EOC is saying yes, those pre-screening questions are subject to the ADA standards for disability-related inquiries because they are likely to elicit information about a disability. And so employers are going to have to be careful about how they would go about doing that and consider really from a warning standpoint of, as an employer, do you want to be in a position of asking those questions and having to defend whether or not you're asking the right questions, what you're going to do with that information, et cetera. And we're going to talk more about some other options that an employer might have rather than putting themselves specifically in that role of asking those questions. An employer would have to show that the questions are job related and consistent with business necessity, and that they have a reasonable belief that they are entitled to ask those questions, and that an employer who does not answer the questions and therefore does not receive a vaccination would in fact pose a direct threat to the health and safety of her or himself or others. So that would be a standard that the employer has to meet. But the EEOC says there are two circumstances that they're offering where those disability-related screening questions might be asked without a company having to meet that job-related and consistent with business necessity requirement. One is that the employer offer the vaccination to employees on a voluntary basis, because if you're not mandating that the employees take the vaccine, and if it's voluntary, then the fact that they're being asked the questions and allowed to answer those questions would also be voluntary. Therefore, you're not triggering those same legal obligations. And if an employee chooses not to answer the questions, and then the vaccine is not administered, then the employer cannot retaliate against that employee for declining to answer the question. But pursuing this option on a voluntary basis might help the employer get away from that standard that the ADA would otherwise impose. Another option the EEOC says is that an employee receive the vaccination that's required, but not from the employer itself, but from a third party that does not have a contract with the employer, such as a pharmacy or a healthcare provider. So the EEOC is essentially saying another option could be mandate the vaccination if you would like to, but don't take on that responsibility of actually administrating the vaccination yourself or on your premises or through a third-party contractor. Instead, go to the outside, go to someone you don't have a contract with, a pharmacy or a healthcare provider, require your employees to go there to get the vaccine, let them ask the questions. You're not then, as an employer, receiving that information in any way from this outside vendor, so to speak, that you're using to administer the vaccination on a mandatory basis. And that way you are protecting yourself as an employer from this whole issue of whether or not you're asking disability-related screening questions and justifying your right to do so, and being in a position of then having to decide what to do with the information that you receive. Just basically farm that out to someone else to take care of and eliminate that risk for yourself. So some good suggestions potentially from the EEOC. In addition, this new guidance that was published recently talked about, specifically ADA and Title VII issues regarding mandatory vaccination. So again, this new publication is basically telling employers, yes, we believe that you can require vaccinations of your employees once they become available. And so the question is, if an employer requires vaccinations, how should it respond to an employee who indicates that he or she is unable to receive a COVID-19 vaccination because of a disability? And essentially, the short answer is that you need to consider a reasonable accommodation. So even if you do have a mandatory vaccination program, employees can raise concerns about whether they believe they should be vaccinated based on their belief that they have a disability that would preclude them or should preclude them from receiving the vaccination. And if an employee raises a legitimate disability concern, then the employer is going to have to listen to that employee, understand what the potential disability is, evaluate whether you as an employer have a qualification standard whereby you could argue that if that employee declines to receive the vaccination because they have a disability, and if that employee continues to want to work in the workplace, could you establish that their presence in the workplace in an unvaccinated state could pose a direct threat to other employees or in the workplace? And you'd have to go through that analysis of determining whether, based on what's called an individual assessment, using a 4-factor test that I didn't include here, but the EEOC has published before, to determine that this unvaccinated employee shouldn't be allowed in the workplace, and therefore you have to respond to that concern. So one, you'd look at, do they have a disability, and can we allow that employee to continue working, or can we exclude that employee from the workplace because they have not been vaccinated? So the employer would then work through what's called a reasonable accommodation and undue hardship evaluation before they decided whether or not they should exclude the employee. And exclusion doesn't necessarily mean termination. Exclusion just means we believe that you employee, you've raised a legitimate disability question, so we're not going to require you to be vaccinated, but at the same time, we've decided that we can't have you working in the workforce because of the risk that you would pose to us, and therefore you're excluded from the workplace, but we aren't necessarily terminating you. I'm not saying that there's no circumstance where you couldn't terminate an employee, but that shouldn't be the assumption by the employer that exclusion is the same as termination. So, once we've worked through that analysis of determining whether or not the employee has a legitimate disability, whether or not we can reasonably accommodate them, whether it's an undue hardship for us, we would determine whether or not we're going to return them to work. That undue hardship and reasonable accommodation analysis would include considering other options. For example, we may want to say, well, can this employee work remotely? Or can this employee work in a location where they're not going to be in contact with other employees? And so those would be options that the employer would run through in their own mind to determine whether or not they can reasonably accommodate this individual with a disability. And then the second issue that the EEOC raises in terms of a potential exemption for employees is if the employee says, I don't want to be vaccinated, I don't think I should be vaccinated because I have a sincerely held religious practice or belief. And so if an employee raises that as another objection to being vaccinated, then the employer would have to listen to those that objection, evaluate whether or not this employee does indeed have a sincerely held religious belief or practice or observance, to determine whether or not it's an undue hardship to accommodate that religious belief or practice, and then determine whether or not they're going to exclude that employee from the workplace as well. That is, to honor that employee's religious objection to determine that they are not going to be vaccinated and what the next step would be. So the EEOC says that, as we're evaluating that religious objection, employers should generally assume that the religious objection is well-founded, but if you have a good basis for questioning that religious belief or practice, then, and you have data or information that causes you to legitimately challenge it, then you can do so and talk through that issue with the employee. All right, so in terms then of what the EEOC is telling us, essentially they're saying that mandatory vaccinations by employers in the United States, and of course including California, are okay, subject to some of these exemptions. So I mentioned already the disability accommodation exemption, the religious accommodation exemption. Some employees might also object based on political views that we may or may not have to accommodate or consider. Some employees have strongly held views, for example, anti-vaxxers, about vaccinations in general, and so we need to at least consider those concerns raised by those individuals. The latter two that I mentioned may not have the same legal support as the disability and religious accommodation, but we certainly would need to listen to those employees and take those concerns into account before we rush to either vaccinate or terminate. And then there's just generalized fear among some people, some trepidation about whether they want to receive the vaccination and what the results of those vaccinations might be for them. So these are all things we need to at least be sensitive to in evaluating the employer's response to rolling out a voluntary or mandatory vaccination program. Some other risks to consider as you're contemplating how you're going to address this issue in the workplace is, could there be workers' compensation claims that arise because of an adverse reaction to the mandated vaccine? And the answer is yes, that's a potential risk for employers if the vaccine is mandated. I think less risk if it's voluntary, but potentially some risk there as well, but certainly greater risk if it's mandated. Another potential risk is under the National Labor Relations Act. That is a statute, a federal statute that is generally providing jurisdiction to the National Labor Relations Board on union management relations, but the act has many parts that are applicable to even non-union employers, and one of those is the Section 7 of the act that protects employees who are engaged in what are called protected concerted activity. So if you have, 2 or more employees who are coming forward expressing concern about some term or condition in the workplace, which in this instance could be your vaccination program or even the discussion about vaccinations, then the fact that they're bringing that information or those concerns to you on behalf of other employees could entitle them to protection under the National Labor Relations Act. And you'd want to be cautious about disciplining or engaging in some type of adverse employment action against them for expressing those Section 7 rights. At-will employment is another legal concern to consider. Some employers might say that, well, California is an at-will employment state. I'm an at-will employment company. It says so in my employee handbook. I've reinforced that every chance I get. So if one of my employees decline to be tested, then I'm just going to terminate them because I'm an at-will employer. Well, you need to be careful about that approach, because at-will employment, although a very good thing for employers to have in place and a good protection for employers to include in employee handbooks, et cetera, is limited in its protection for companies. In particular, it limits its primary protection is protecting companies from certain type of breach of contract claims, but at-will employment does not protect a company from a claim that it terminated an employee for reasons that are protected under the law. So, for example, if you terminate an employee because they're in a protected status or they complained about sexual harassment, then your at-will employment policy is not going to be a defense to a claim for discrimination. So we just need to think through, the limitations of at-will employment and its protections for employers, even though it is a good practice and policy to have. You have to look at your own jurisdiction. If you are an organization that has operations outside of California, different states will probably be reacting differently to the whole vaccination issue. Some states could very likely pass laws that specifically mandate the vaccine or give rights to employers to mandate the vaccine. So you'll have to continue to watch both what happens inside California and outside California. The industry you're in may also make a difference. Certainly we can see how the medical community and certain food processing plants, might have a greater need or desire to impose mandatory vaccinations than other organizations. And of course, all of us want to protect our employees. All of us want to have a safe workplace and to eliminate the pandemic. But I think certain companies would have greater and stronger arguments to support the mandatory vaccine. And then if you are a unionized workforce, then there could be also issues that arise in terms of dealing with the union. If you as an employer are going to implement a mandatory vaccine program, then that's something the union is going to want to be involved in, and you may be prudent to engage in discussions with them about how that's going to be rolled out to the workforce. Some additional frames of reference as you're debating, internally for yourself how you're going to approach this is understanding that across the country, not all, even medical communities or medical employers require influenza vaccines and other vaccines. Many of those organizations, just strongly encourage employees to get those vaccines. But if an employee declines to get the vaccine, they oftentimes will require them to sign a form acknowledging the risk and formally opting out of that process. So that's a procedure that employers could implement in the context of COVID-19 as well. Cal OSHA, for example, typically does not mandate employees receive hepatitis B vaccinations for those organizations that have employees exposed to that, but does require that employers make it available. So there's that distinction between mandating employees take it versus mandating that the employer make it available to the employee. And then, as we've seen historically with not a lot, fortunately, but other pandemics across the U.S., typically those did not result in mandatory vaccination programs, even though court decisions have authorized states to impose those type of requirements. So in summary then, to get back to the big question of can you mandate that employees receive the COVID-19 vaccination, the answer is yes. There is strong legal support for requiring employees to receive the COVID-19 vaccine. That support became even greater in the last 24 hours with the new publication from the EEOC. And we may see additional support coming from CDC and or Cal OSHA in the coming weeks and months as well. Certain industries have stronger arguments than others about the direct threat created by COVID-19, but we do see the EEOC essentially confirming that for businesses across the country, they have a good argument that this pandemic is creating a direct threat for employees in the workplace. If you do decide to impose some type of mandatory vaccine program, or even if you decide to use a voluntary approach, all employers are going to have to consider those exemptions, the disability, the religious, the political, as they determine what their program is going to look like. And you'll have to consider the additional risks that I just mentioned, such as workers' compensation claims, National Labor Relations Act, and what you're going to do with employees who decline to be vaccinated. And then if you do implement a mandatory vaccination program, consider carefully how that's going to be done. Will it be on site? How will you handle disability related questions? Will you use outside resources to actually administer the vaccine as opposed to doing it on your own? And so that maybe brings the second big question of, even if we can impose a mandatory vaccination program, should we impose a mandatory vaccination program? And so, we think through these issues, recognizing that there is risks and that there is risk and there's uncertainty. You should at least consider other options, such as a voluntary program. Like the EOC states with respect to the influenza vaccine on the one slide I had earlier, employers may want to consider encouraging but not mandating vaccine, that is making them voluntary. Perhaps implementing some type of reward system for those who get vaccinated to encourage them to participate in the voluntary program. Perhaps consider bringing the vaccine to the workplace, still with an outside vendor perhaps, just to make it easier for employees to get the vaccine. And then perhaps as the leader of your company, consider being a role model by getting the vaccine early and encouraging other employees to do the same. All right, so I'm going to stop with all of that. I know that's a lot to digest, and turn it over to Tracy and Juanita to talk about some of the other considerations on this important topic.
Terrific. Thanks so much, Dan. Meaty information. Wonderful. We have a few questions I'd like to throw at you real quickly before tossing it to Juanita. One in the chat and some prior to this session. Tammy's asking, what if your workers' compensation provider requires your essential employees to be vaccinated in order to cover them under the policy? She says this is based on the presumption statute in California. So Dan, could you respond?
And just one clarification on that question, Tracy. Mm-hmm. I believe Tammy's organization is a critical infrastructure organization as well. So they are not just essential workers, they are actually critical infrastructure.
Great, okay, wonderful.
So if the carrier, if I understand the question, it has to do with whether the workers' compensation carrier is imposing on the employer the obligation to have mandatory vaccinations?
Yeah, that's how I'm reading it.
Okay. Well, I haven't heard that that's happening yet. It's probably early, but still, it's a good question. What if the carriers impose that requirement on employers? And I suppose that would, if that's a condition essentially of keeping your coverage with that carrier, then you're going to have to take that request very seriously. From the carrier's perspective, I could see how they could want to impose such a requirement like that, because we have just recently signed into law in California some new laws, including SB 1159. And 1159, which went into effect as soon as the governor signed it on September 17, 2020, creates this rebuttable or disputable presumption that employees who contract COVID-19 who were reporting to work, that COVID-19 infection then is covered by workers' compensation, that it's a workers' compensation covered illness, essentially. And so from the carrier's perspective, they know that although it creates a rebuttable presumption, it's not an absolute that just because the employee contracted COVID-19 and happened to report to work, that it automatically means that it is work-related. And so the statute itself, SB 1159, says that an employer can dispute this positive COVID-19 test by showing a few things. One is that they can show that there were measures in place to reduce the potential transmission of COVID-19 in the employee's place of employment. And since there's other factors as well, but that's, I think, the key one here. because from the carrier's perspective, if they're going to mandate the vaccinations, that would be a great argument to use against the presumption that that COVID-19 positive test is work-related, because the employer took the aggressive step of mandating vaccinations, and so they would use that to show that there was a quote-unquote measure in place to reduce the potential transmission of COVID-19. So I can see why the carrier might impose such a requirement, because they're going to be looking for tools to defeat that presumption.
Great. Okay. I'm going to toss it over to Juanita Webb now and let her enlighten us. And we'll get some more questions in as well, Juanita, if you're okay with that.
Yep, absolutely. And thanks, Dan. That was really, I know it seems like a ton of information. And for those in the audience, we are recording the presentation as well, and we'll make the slides available afterwards so that obviously you can then follow along or go back and review all of that. So just a heads up for you. So I really want to just touch on 3 topics to follow up on what Dan said, more on the practical. How do we do some of this? How do we deal with some of those considerations, whether we're going to mandate the vaccine, or how do we handle some of those accommodations? What do we need to do in the workplace? How do we handle those? And then even what do we do with those who may refuse or not want to participate if we do either decide to make it mandatory or a condition of employment? So just one thought to keep in mind, just remember that just because a person is vaccinated doesn't mean that they can't be a carrier and infect others. So it's really important to keep in mind that what we're doing is trying to help eliminate as much spread as we can, but just because you get vaccinated doesn't mean that you can't spread it to others. And so the vaccine really just helps to keep you safe and you more protected from the severe symptoms of the disease, but it doesn't mean that you can't carry the virus and spread it to others. So we're going to still be social distancing, sanitizing, avoiding large gatherings, wearing masks, limiting our travel. We're not going to be getting back to normal anytime soon. So that's something to just keep in mind and help our employees understand that the vaccine isn't this great magic wand that's going to solve all the problems. We still can be spreaders of it. Other things to keep in mind is that the concern that since the vaccines are currently only under an emergency use authorization, they still have not been fully approved by the FDA. And there has been some discussion as to whether or not restricting or requiring employees to take the vaccine, since it's not been fully approved by the FDA. There's still a question in that area. So that's important to think about. So if an employer does want to require the vaccine, what are some things we need to consider in regard to the day-to-day dealing of it or the day-to-day implementation of it? So the first one I would say, for those of you who are unionized workplaces, be sure to engage the union. Hopefully you can get the union to work with you to encourage workers to take the vaccine, but you need to deal with them, work with them, negotiate if necessary, if that's what's required because of the union situation. The other thing to take into consideration is the cost. Anything that I have read has indicated that the vaccines there's not supposed to be a cost associated with the vaccine itself. However, if you're requiring that an employee get the vaccine, you are going to have to pay for the time that the employee takes in order to get the vaccine. So it would need to be done on work time because you're requiring it and making it a condition of employment. And remember, the vaccine is a 2-stage vaccine. So you're going to have to pay for it twice, and they're a month apart. The consideration there is that if an employee takes the first dose and potentially has some maybe negative reactions or some side effects that occur, you're going to have to really strongly encourage them to go ahead and get that second dose. And according to information I read late last night, the dose has to be by the same manufacturer. Both doses for the vaccine have to be by the same manufacturer. So if an employee takes a Pfizer dose for the first dose of the vaccine, they have to take the Pfizer vaccine for the second dose of the vaccine as well. Other things to consider is because of those side effects, that if an employee does take the vaccine, that there may be absences in your organization. And so that's something to consider. Some of the side effects, the myalgias, the muscle aches and pains, the chills, the headaches, the exhaustion. Read another article yesterday about I believe it was Alaskan native nurse who took the vaccine and within moments had an anaphylaxis or an allergic reaction. And so just keeping in mind that those kinds of situations can occur, and how are you going to handle those or assure that you've got coverage for your business. So what we really are thinking about is there's going to be a lot of paid time that is non-productive time. So you're going to have reduced productivity, potentially if there are a lot of reactions to the virus or side effects and you're mandating the vaccine, then that's going to be under your workers' comp, which could potentially ultimately increase your workers' comp premiums as well. The other thing to consider is staffing issues. Staggering it so that you're not giving the vaccine to an entire department or an entire division, because if they do have side effects, that whole division or department may be absent or need to take time off. The other thing to consider, even if you don't mandate the vaccine, would be to ask employees when they are anticipating taking the vaccine so that you can anticipate potential absences as well. So if they say, hey, I'm going to go get the vaccine, great. What day are you doing that? Knowing that potentially the next day they may be calling out sick or not be able to come to work because of the side effects of the vaccine. One of the other things, and I wanted to capitalize on this because Dan brought up a couple of times about being able to provide some indication that the vaccine, that an employee's disability, they can't take the vaccine because of a disability, and you have to be able to demonstrate that they're unable to do the essential functions of their job. So I would really encourage you to make sure that you have current, up-to-date, essential function job descriptions. Not just a job description that says they do this, this, and this, and lists some tasks, but to also indicate some of the physical requirements of the job, some of the physical exposures that they might have, the working conditions, whether it's inside or outside, should be included on those essential function job descriptions, so that if you do need to make some kind of an accommodation for a disability, you can prove based on an established job description how you can do that. So just one thing to think about as well. The other thing to think about is that you may not require the vaccine for your employees, but your customers or clients may choose to require it for someone who's entering their facility or working on their facility. And so you need to make sure you reach out to your customers, your clients, to find out if there's going to be any of those types of restrictions, so that you can assure that employees that are assigned to that facility or are going to be sent to that facility to perform duties have been vaccinated or are willing to be vaccinated and don't have a disability or religious accommodation need. Those who maybe have to make deliveries to the hospitals, or if you're a temporary staffing agency and you may not require it for your employees, but if you're assigning those employees to locations where it is required that they have the vaccine before they work there, you may have to make it necessary for those employees as well. Requesting evidence of the vaccine will be important as well. So if you do it on a voluntary basis, make sure that you are getting some kind of evidence that the employee has actually taken the vaccine. Typically what a medical practitioner will provide is some kind of a little card or written statement that the employee has taken the vaccine. Just be very cautious, and you may want to warn your employees to ensure that there is none of that those medical questions, as Dan was referring to earlier, or even genetic information included on that card that they provide that shows that they've had the vaccine, because those questions that the medical professional may have to ask about medical history or family history may potentially be written on that card. And we need to make sure employees are not providing that to us so that we can demonstrate that we do not have any of that medical information. And by the way, Dan has put up a slide for me there where it's providing some resources. And the third bullet down is referencing just what I mentioned. There is some model language for a warning to the employees to not disclose medical or genetic information. And I've given you the Code of Federal Regulations there where you can pick up that model language. So that should be helpful to provide that kind of warning to the employees. So then what do you do if you have an employee who needs an accommodation? How do we handle that? Well, my encouragement to you would first make sure that your supervisors and managers know how to recognize a request for an accommodation from an employee, because there is no magic language. There's no specific wording that the employee has to come and say, I'm specifically requesting a medical accommodation because I have a disability. They don't have to say that. You might hear an employee come to a supervisor and say, I've really been praying about getting the vaccine, and we've been discussing it in my church, and I just don't know if I want to get the vaccine. That may initiate enough understanding to consider a religious accommodation for that individual. And so make sure your supervisors and managers know how to recognize that, and remind supervisors as well that it's unlawful to disclose that an employee is receiving a reasonable accommodation, or to retaliate against an employee for requesting an accommodation. So that's important to know as well. Also inform your employees as well as your supervisors and managers who the person that they should be referring requests for accommodation to. Have a consistent funnel where all of those individuals are being funneled to, so that you can have a consistent process for determining those accommodations. Is it going to be somebody in your environmental health and safety department? Is it going to be your HR department? Is it somebody in your C-suite? Who is it that's going to be determining these accommodations that may be necessary, and whether that decision can be made? I would also encourage you, prior to having to make some of those decisions for accommodations, that you start looking at what are some things we can internally identify that may be options available for an employee who needs an accommodation. Things like off-site work, working in a very separate location. Dan mentioned earlier, moving them to an area where there's very little exposure to others, maybe putting them in a staggered schedule where everybody that's had the vaccine comes in early, those who haven't come in maybe on a later schedule, just so that you can keep that separation, and again, try to do as much focused protection as you can. Do keep in mind that undue hardship standard that Dan mentioned, because if you can demonstrate as an organization that providing these accommodations would be an undue hardship, there is a possibility that you could deny the accommodation. I would strongly encourage you to work with your HR professionals or consultant, or with legal counsel, to make that determination before you take any action to deny a reasonable accommodation to someone. Dan also mentioned maybe providing some incentives. What are some of those incentives for either complying or voluntarily getting the vaccine? Well, things like, hey, you don't have to go through the temperature check process every morning, or they could be wearing less restrictive personal protective equipment. They get to work in the office and not remotely. For some, that would be a reward. Some of those parents would like to get back to being at the office and not being home with all of their kids as well. You can potentially offer a cash bonus. Just be very careful with that as well. And then what do you do for those who maybe are some non-incentives if they're not going to get vaccinated, that they have to work alone? They will have to be separated so that they're not being exposed, or that they will have to wear more restrictive or rigorous personal protective equipment, or they'll have to do additional sanitizing throughout the day more often to ensure that they're not being exposed. And then what do you do if an employee actually does refuse? How do you handle that? What's the discipline for an employee's conduct that defies any of these safety policies or public health guidelines? Well, can you discipline them? Yes, you can, just as you can for any other policy violation. So that's why it's so important to have this standard established. Get your policy in place regarding how you're going to move forward with the vaccine, and whether it's going to be a requirement or not. And by the way, you'll notice on the fourth bullet point there, the Cal OSHA template for the written COVID prevention program. That's a new standard that was required by the Cal OSHA laws that went into effect November 30th. And every employer or employers are required to answer that, or to provide that, excuse me, just as you do for your IIPP, your Injury and Illness Prevention Program. So that is a new standard that's required. The link that you go to there at the Cal OSHA will give you either a Word document or a PDF. You can take the Word document and adjust it to fit your company, and so that way you are in compliance with the new requirement to have that written COVID prevention plan. And by the way, I failed to mention those first two bullets. That has to do with accommodation. The Job Accommodation Network, known as JAN, gives you some good information. It even gives you a toolkit for workplace accommodations. And so you may choose to go to those websites and look into those. If you do need to give some accommodations, that may give you additional insights or how you can provide those accommodations for those who may need either religious or disability or political related accommodation. So back to the discipline, yes, you can discipline them for even off-duty conduct that could potentially be an issue for the workplace. So if it affects the workplace, there may be a reasonable basis for corrective action. Just read another article about a nurse who was out and went to a large gathering and was flaunting it on social media. And we're going to let Tracy talk about that in just a moment, but how she was flaunting it and that she was coming back into the workplace after flaunting it and participating in this large gathering where she was exposed to COVID. So those kinds of things you can discipline based on your policy. Is there a legitimate reason for disciplining the employees? Well, if they're threatening the health and safety of others, then there's absolutely a reason to do that. Are they infecting others or spreading the virus to clients or customers? My encouragement to you would be to make sure that you can identify what the specific conduct was, what your policy is that was violated. And because I'm a good HR professional, document, document, document. Please make sure you keep records of all of this. Describe even the impact that this behavior of the employee had on the company and what the expectations are going forward and the time frame that they have to improve. Just also keep in mind the NLRA Section 7 that Dan mentioned with regard to protected activities, especially when an employee is posting on social media or making comments, whether they agree or disagree with your policy. If you decide you're going to require the vaccine and they want to talk about it or post about it or make comments about it out there on Facebook or the social media sites, please make sure you're staying in good contact with that, aware of it, and then work with Tracy to get answers on how to deal with that. So Tracy, I'll turn it over to you and you can address all of those kinds of concerns.
Awesome. Thanks, Juanita. Appreciate all that great information. We've got just a little bit of time left, perhaps 9 minutes. So I would, rather than get into details about specific circumstances on social media, which of course can be a lot of fun, and our team works in that space every day on behalf of our clients, running their social media channels and websites and everything. But I want to give you 4 big communications initiatives you should undertake if you're going to have a policy described by Dan and Juanita. First, if we were working for one of our clients, large or small, we do a frequently asked questions or a Q&A, if you will, right? You know what your employees might push back with or ask or inquire. So write those up, create answers and responses so all your management team's on the same page. Run those by your HR professional and or your attorney. Get it all perfected and finalized. And again, that's your management team's guiding documents so that they respond to questions exactly the same. Stay on message, do not make it up, do not deviate, do not pass go, do not collect $200. You got to stay in your lane and follow what the guidance you've received from professionals like Juanita and Dan here. So create that. It'll help you do everything else I'm going to describe. Second, internal emails, of course, create that. How are you going to share this with your employees? Craft those messages and emails and comments, however you're going to share this, and over communicate with your employees. One of the things we teach in our shop is communications is so vital, and your employees should be your biggest allies in person and online. They're your team. So they tend to act out and vent when they feel frustrated, not included, their questions aren't being answered, they're being ignored. So over communicate, give them many, many, many ways to talk to you and get responses and answers to all of their questions. That will help you tremendously with that whole social media outburst thing that is not fun typically for most employers. On that topic, number 3, create your, if you have social media channels, and I hope you do, because in most circumstances, this is vital for you. It's yours. You control it. It helps you with your brand. It helps you market. It helps you do so many things in the communication space that are vital for you. So create those social media messages. No, they do not need to be about vaccines. They should be whatever. We create strategic plans and create content ahead of time, and it has an objective for that particular company. Keep doing that. Keep doing your positive messages. Talk about your culture, your mission, your vision, your values. Stay on point. Don't go radio silent, and check it much more often when you roll out a policy like this. Keep tabs on what people are saying. You're going to want to respond to those negative comments. I don't have a great deal of time to get into that, but don't panic and don't ignore negative comments. They fester. People assume it's true, and if it's wrong, you need to correct them quickly. And it's good for the entire audience. Sometimes that one individual being cranky with you, maybe it's a former employee, maybe it's a family member of employees, maybe it's a competitor. It could be all sorts of things. So don't let it lie there and fester. Correct it, and educate everyone else reading that post, not necessarily that person who may not have a pure objective there. And that's okay. Think about the entire audience watching that communication from your company, and kill them with kindness, we like to say. It's the worst thing that can happen to a person who's being very, very angry and hostile and maybe spreading misinformation. Give a very fact-filled, polite, professional response. This will help you tremendously on social media. Last, our clients hate it. You could get a call from media, particularly a larger company. It's very easy for employees and all the aforementioned stakeholders to reach out to reporters these days. They can call, they can email, but lots of times we've seen it often. They go on social media and just tag KGT, tag a reporter at KBAK, tag that writer with the Californian, and they inquire. So we do holding statements. This isn't complicated, but in the PR world, we call it a holding statement. So again, be prepared. Preparation is going to help reduce your anxiety and help you feel more confident about whatever you decide to do in your shop. So do that holding statement, why you're doing what you're doing, what are the benefits, the reasons, and what your company's all about, your values, and how this fits within that. So write that up and be ready and set it aside. And then if somebody calls, you thoughtfully consider it. You may need to tweak it. They may have a different angle. But you're ready, and you don't have to panic when you get that phone call. So those 4 things: create an FAQ, a Q&A, be ready, educate all your management with those same messages, get them all feeling confident about what you're doing. Create those internal emails, get them vetted by your HR and your legal counsel, and create your social media content. Stay on point, stay on message, and be more diligent about monitoring your pages. And then finally, that brief paragraph holding statement for any media inquiries, should that occur, you're ready and you're good to go. So hopefully that helps you all with your communications and staying very, very organized. I wanted to ask this question, if I could, of either Dan or Juanita in our remaining 3 minutes, and y'all feel free. I'll ask Allison to post all of our contact information again, in case you want to get in touch with any of these folks. They can definitely help you. Thank you so much, Allison, for doing that. Question prior, Juanita or Dan, how can we keep our employees and residential clients fully informed of the risks present without violating HIPAA? And will employers be indemnified if an employee or client believes they contracted COVID at our facility? You might want to revisit that. Dan, I think you touched on this a little bit. But those 2 questions, if you could.
Right. Did you want to tackle that, Juanita?
Nope, I'm going to let you go for it, Dan.
Okay, very good. So I guess in terms of the latter part of the question, can you'd be indemnified if client, I guess client employees, I think was the terminology, contract COVID at your workplace. So I assume from that question that you may have visitors who are coming onto your property from other organizations, and then they are claiming that they contracted COVID-19 at your place of work, your premises. I suppose you could attempt to have them sign an indemnification agreement of some type, but I don't know how enforceable that would be. I think that would be difficult to actually to enforce that type of indemnification agreement is my first reaction. And what was the first part of the question again, Tracy?
First part was it's a care facility and they wanted to know how can we keep our employees and clients, residential clients, fully informed of the risk present in the facility without violating HIPAA.
So HIPAA, primarily has to do with what's called protected health information. So, it's a pretty limited scope of information that is truly protected by HIPAA. So as long as you're not divulging specific medical information about individual employees to the employees or your residents in your facility, then I think the likelihood of violating HIPAA is very small. So I think keeping that information generalized. So for example, let's say you do communicate that someone in the organization has contracted COVID-19, but so you could communicate that information, but not be specific about who exactly contracted COVID-19 or what their medical symptoms were, diagnosis, and those type of things. I think that you would be effectively communicating your concern, putting them on notice or giving them the appropriate warning if that's your objective, but not violating HIPAA.
Okay, great. Perfect. It is exactly 11:15. Thank you everyone for joining us. We appreciate your time and understand you've got a lot on your plate with this issue, and hopefully you got a lot out of it. The information, again, our contact information is there, and I'm sure Hillary can share it as well if you reach out to her. She has all of our numbers, so happy to speak with you if you've got bigger issues to go over. I think that's it. And we will also, I think Hillary noted in here, you're going to make the deck available, the recording of this session. And we're hoping, we've had a lot of requests, Dan, for your PowerPoint as well.
And just one other comment, if I can throw in, Tracy, at the end, I would really encourage organizations to kind of capitalize on your aspect of contributing to this, that employers need to have some kind of a internet communication policy in place. And so they really need to review their policies to ensure that they have that. Do they have a policy that talks about, what employees can do and say out on the internet, blogging, tweeting, posting, all of those kinds of things? And so they should have that kind of a policy in place. If they don't, obviously contact your legal counsel or Dan. He has those types of policies available that can assist you. But it's important that they put that in place. So again, they have something to refer to if an employee does violate that policy. So terrific advice. Thank you all. Hope you have a wonderful day. Appreciate you joining us. And again, don't hesitate to reach out, and we'll look forward to speaking with you all again. Thank you. Thanks so much. Goodbye, everyone.
Thank you.